I'm going to be talking about analyzing a legal case or problem. And I'm going to keep this short talk. I'm going to keep it extremely short and sweet and talk in a very general manner about how to analyze a legal case or problem. Along the way, I will give you some tools which you can use to analyze a case and how to think about a problem, and what thought processes you should be going through when you are presented for the first time with a legal case. While this talk will primarily deal with civil and commercial cases, the principles that I will speak of apply to any legal problem or matter, including criminal, family law, etc. And the four topics that I'm going to primarily cover are, firstly, how to approach a legal problem or case, that is, the attitude that one should have when approaching a legal problem for the first time. Basic preparatory work required in initial work that you need to do. Then the IRAC method of analysis, that is IRAC method of analysis. And then how to train your mind to think like a lawyer. So these are the four topics that I will cover. Firstly, let's talk about how to approach a legal problem or a case. This is the attitude that you should have when you are given a new brief or documents for that matter and asked to prepare a brief. A legal problem, like any other problem, perhaps other than those involving human emotions, should be dealt with extremely logically. Ideally, you're looking for a solution to your client's problem. Therefore, you need to look at it from a calm, focused, and composed perspective. Even in the most difficult of matters, where it seems that everything is stacked against your client, there is usually at least a few points which you can argue which are in your favor. Be patient and look out for those points. Every case you will find the weakness of the other side. You need to exploit that weakness. So therefore, you need to analyze the case in detail. Don't get intimidated by the number of papers, volume of pleadings, number of exhibits, or size of the brief. That is a very basic mistake that a lot of people make when being approached to appear in a matter for the first time. If the pleadings have already been filed, of course, you need to read the brief. But just reading every single page is neither convenient nor very efficacious. So how does one do it? The first thing is that you need to read, if it is already a prepared brief, if it is a brief which has been filed in the court, for example, a suit, a writ petition, etc., then you need to look at the prayers. The first thing that you look at. This will give you the reliefs that are being asked for, and you will therefore get an overall perspective of the nature of the proceeding and what the proceeding is all about. Then, of course, you need to read the facts. When you read the facts, you will come across certain exhibits which are referred to in portions of the brief. Exhibits or documents are those which are relevant to the matter. So as soon as you come across it in the facts, open the document. After reading the document, seeing the relevant portions, go back to the pleading and continue onwards. You will find it that this is a far more effective way to completely read a brief in a matter of hours sometimes, as opposed to days. Reading a brief should be done in an effective way, in a logical way, and therefore, while you're reading the averments in the plaint or in the pleading, you should actually read the exhibits as well, and not the other way around. By that, I mean that you shouldn't read all the pleadings and then all the exhibits, because then you won't get a perspective of the matter as an overall picture. If pleadings are not filed and you are given a stack of documents, the first thing that you need to do to organize your matter is to organize the papers in a chronological manner. This is actually the literal first step that you need to take before even reading the papers. Now, while you should be aware, while reading the documents and the pleadings, of the difficulties in your client's case, you should also be solution-oriented and look for the best way in which you can present your client's case to the court. The point is to be positive and solution oriented, because sometimes the more time that you spend reading and thinking about a matter, the more difficulties and infirmities you find in it. So don't let yourself get bogged down from the get-go. Your attitude must be inquisitive, curious. Ask your client questions, ask them difficult questions, ask yourself questions also, and come to conclusions on the basis of the answers to those questions. One interesting tool that is used often in legal analysis or legal debate rather is the Socratic method, which you can use with your colleagues, your client, etc. And according to various definitions, the Socratic method is a form of cooperative argument. It's a dialogue between two individuals. And it's based on the asking of questions and the answering of those questions to stimulate critical thinking and to draw out ideas and underlining presuppositions. So basically, you will, rather than providing an answer to a question, you'll ask a question and let the other person give you their perspective on the answer. And then you can have a debate through that process. So essentially, it is also a method of teaching which is used in law schools around the world. And it was originated by Socrates, the great philosopher and thinker. And it is also used to teach law through logical questioning rather than providing answers. So this can be used to debate the pros and cons of a case. Then we come to the next point, which is basic preparatory work. So while you read the pleadings or the papers, in case the case has not already been filed, then you need to take some rough notes. What you need to note down, of course, this is extremely basic level stuff, but I'm going through the paces and then we'll come to the more detailed points. But you need to take notes of the dates of the relevant documents and what they say. The purpose of making these rough notes is so that you can have a guide. And the other purpose of making notes, and a trick that I find particularly useful, is that the more I write down the facts of a case, or those which are at least material and relevant to the case after reading them, the more I become familiar with the case. Because you're almost committing to memory that which you're reading when you write it down. After that, and this is something which is extremely important, you must prepare a chronology of the relevant facts. And this is known as a list of dates and events. Now, this is the most important document which I've spoken of before, which can help in your analysis. Ultimately, the facts are the backbone of any case, and therefore you need to know your facts inside out, or at least have them in one tabulated form which is easy to read. And therefore, this list of dates and events is something which is a must and should be prepared prior to analyzing any case. Now, this is the basic preparatory work. Let's get into the meat of the problem. And the meat of the problem that we are faced with today is how do we analyze a legal case? And one tool which I've learned, which is taught in law schools, particularly in the US and Canada, is the IRAC method of analysis, which I'm sure many of you have heard of. And it's a very versatile tool, and I'll tell you why. But young lawyers need to be able to understand and employ legal analysis to effectively serve their clients. And legal analytical skills are required for nearly every legal activity in which one engages. I mean, some of the common places where you may employ this method of legal analysis are in assessing the merits of a prospective client's matter, or reviewing case law for that matter. It can be used as an aid to help determine what evidence is necessary to prosecute or defend a case. Practically every aspect of legal writing but including but not limited to writing case briefs, memoranda, even memorials in moot courts, legal briefs, appellate briefs, etc. They can all use this method. And you can also use it to write answers in your law school exams because you have a structure. And teachers love structure when you're answering a question. So therefore, it can be used in a number of ways. And ultimately, if you become a judge or an arbitrator, this method can also be used to structure an order or award or a judgment. So really, it's an extremely versatile tool, which we'll get into presently. Of course, this comes after the stage of making the chronology and writing down the procedural history and the facts of the case. Now, what is the IRAC structure? What does IRAC stand for? The IRAC method is a framework for organizing your writing and for analyzing a legal problem. And the basic structure is this: I stands for issue, R stands for rule, A stands for analysis or application, and C stands for conclusion. Using this simple framework, you can structure any legal problem and put it in a comprehensive and comprehensible manner and give a complete written answer to the problem. So let's look at it step by step. And for this analysis, I'm going to take an example of a set of facts which I've just formulated, and we'll use that to look at the issue, the rule, the analysis, and the conclusion. So the facts are: the plaintiff company is the former employer of the defendant, who is an individual. At the time of joining the plaintiff company, the defendant had signed a non-compete agreement under which he had said, or he had agreed, that he would not join a competing business for 5 years after leaving the plaintiff company. So it's a post-employment restrictive covenant. Now what happens is he leaves that company, the plaintiff company, and immediately after leaving the plaintiff company, he joins a competing business. So the plaintiff has filed a suit against the defendant seeking damages for breach of the contract. Now, can the issue in this case, let's look at the issue. So what the issue is the facts in dispute or the question in dispute. So you have to begin your answer by stating the issue at hand. So what you need to ask yourself for the purpose of this analysis is, what is the legal question that, when answered, determines the result of the case? This is the overall issue that you will be framed. Now, there can be more than one issue, but you need to frame each and every issue. And these are not exactly the detailed issues that we get into when we are trying a suit, for example. This is slightly more general, but the issue should be stated in the form of a question, and a specific question rather than a general question. So the issue is the matter in dispute between the parties. And in the facts that I mentioned before, the issue could be, for example, has the defendant breached the contract between the parties? Or is the plaintiff entitled to damages in view of alleged breach of contract by the defendant? These would be acceptable issues. What would not be an acceptable issue is something general like, will the plaintiff win? Or will the defendant be liable for damages? You have to put in some details and specifics. Now, the next thing after the issue is the rule. And the rule, what rule means is, the rule is the rule of law that you're going to apply. So the rule describes the law or the test which applies to the issue. The rule should be stated as a general principle and not as a conclusion to a particular case being briefed. So, for example, in the present facts, the rule could be, the relevant rule rather, could be Section 27 of the Contract Act, which provides that the agreements in restraint of trade are void. So this is a general rule. Of course, you state what the section itself says, and frequently what happens is the rule will be the definition of the principle of law applicable in the case. There can be more than one rule, but what is necessary is that you list or analyze all the different rules. So you have to list all those rules and step by step look at the different rules. So this is the rule portion of the IRAC method. And by the way, the IRAC method, I would encourage you to write it down rather than having it oral, because this is something which will help you even at a later stage when you want to look at the overall picture of your case. So after issue and after rule comes the most important section, which is the analysis, the A in IRAC. Analysis is the most important and probably the longest part of your analysis, overall analysis. So what it is basically you're applying the rule to the issue at hand. It involves applying the rule to the facts and the problem and the issue. And you should use the facts to explain how the rule leads to the conclusion. So you must discuss both sides of the case when possible. Analyze case law for and against each side. This is very important. Do not come to a conclusion without actually putting down in writing the reasons for coming to that conclusion. So you must analyze the reasons. Don't just directly jump to the next section, which is conclusion. A conclusion without reasons or explanations means you have not applied the rule to the facts to analyze the issue. So you must apply the rule to the facts, and therefore the analysis section is the most important. Ultimately, you can use the rule as a guide to come to the conclusion. So in the present case, for example, the case that I mentioned above, you will have to analyze the various judgments under Section 27 of the Contract Act, analyze the section itself, and analyze all judgments, not just the ones in favor of one side and not in favor of the other. In favor of your client's side as well as in favor of the other side. Analyze all the judgments before coming to a conclusion. But ultimately, of course, you need to be a little pro trying to find a solution to your client's case rather than finding the problems and difficulties in it. So therefore, keep that in mind as well. Now, if the rule is a test with multiple factors, for example, a test under even the Contract Act or under the Transfer of Property Act, then you must analyze each factor by pointing out how the facts apply or do not apply to each case. This is also how you would write a written submissions, for example, when you're submitting it to court. So you must apply the rule to each of those factors. And naturally, if there are multiple issues, there will be multiple analysis as well. So this is the most relevant and important section of the whole IRAC method. And then lastly, we come to conclusion, which is the C in IRAC. The conclusion is your answer to the issue. So you have to state the results of your analysis. The conclusion need not be long. In the present case, as I mentioned, which is a case where Section 27 of the Contract Act is involved, the answer would probably be, depending on the detailed facts of the case, that the agreement is void and therefore the plaintiff is not entitled to damages. Or if there's some nuance to the facts of the case, it could be the other way around. So effectively, this is like the operative part of a judgment or a decree or any order. It is the conclusion. It need not be long. It has to state what the conclusion is. So I hope you found this IRAC method useful, and it's a tool that can be used, as I said, in in various ways. It's extremely versatile. And it's really, really useful. So consider analyzing cases in this manner in the future. Now, I want to briefly talk about the fourth point that I was going to talk about, which is how to train your mind to think like a lawyer. So, the first thing that you need to know is that you have to be inquisitive. When you read something, it is very easy to be defeated or to think that you have a great case. But do not take things for face value, at face value. Dig a little deeper. Ask relevant questions which may be difficult to your client, but which will help you in the long run to anticipate arguments from the other side, as well as to find arguments in your favor. Approach the problem from every angle. See all the possible issues in the set of facts. Look at it from different perspectives, putting yourself in others' shoes, which will allow you to understand other points of view. Now, issue spotting is a very important skill to learn, which is you have to look at the set of facts and find out what the real issues are in your case. It is ultimately what the case will turn on. Another very important thing when you are looking at a problem afresh is to avoid looking at it from an emotional perspective. When you are thinking like a lawyer or an advocate, especially a litigating lawyer who appears in courts and tribunals, it is very important to put your personal thoughts, interests, or emotional reactions aside and focus on the facts and the law. That's it. Do not be prejudiced. Do not think about conduct. Of course, conduct can help prove to a court that what you're saying is correct, but you need to look at it from a completely unemotional angle. Uh, as I said before, argue both sides using the Socratic method. Non-lawyers may perceive this ability as somewhat of a moral failing as such if you are arguing both sides, but there's nothing wrong in looking at it from both perspectives. If you are able to argue both sides, if you're able to look at it from both perspectives, it means that you're able to understand the two sides of each story. Because let's be clear, nothing is black and white, especially when you get a brief. You'll realize that there's no clean case without any difficulties, as well as there's no case against you where you can't find something in your favor. The next point is when you learn how to make opposing arguments, you will also learn how to hear them, which increases your ability to react to them and allows for problems to be solved by coming up with solutions for your clients. Deductive reasoning is one of the most important skills that you can have as a lawyer, and think of any problem logically, as I mentioned earlier. Now, also take nothing for granted. So look at a particular set of facts and understand why it happened. Also understand sometimes why a particular law was enacted. So look at it in a greater detail because that can help change your case. I'll give you an example. There was a constitutional matter which I was uh, lucky to be a part of, which was in the Goa bench of the Bombay High Court. And it was a matter relating to the 10th schedule to the Constitution, an interpretation of the provisions, and whether a particular member of parliament and a MLA rather had been disqualified or not under the 10th schedule. And we really went into depth into the debates that were held in parliament prior to the 10th schedule being enacted or being amended. And we found that it was the Constituent Assembly, when they were creating this 10th schedule, had thought of something completely different from how all the previous judgments related to the matter. So we were able to convince the judge that really the purpose of the 10th schedule was X, whereas previously, or at least it was argued that it was Y. So always look at something from every angle possible and take nothing for granted. And lastly, accept ambiguity, because there's rarely any case that you will find which is black and white. As I mentioned, there are nuances in every case. There are scales of gray in every case. So just because no case is perfectly in your favor or against you doesn't mean that you can't come to a correct answer. Distinctions can be made. Uh, Judges also, therefore, are there in the common law system to develop jurisprudence. That's judge made law. Judges apply the law to diverse facts and come to some sort of an answer. And there sometimes is no correct answer. So learn to accept ambiguity. Ambiguities allow for flexibility so that every time you have a law, you don't need to write out every scenario possible, and ultimately look at the case from all angles. That's all I have for you guys today. So I've got a few questions. While analyzing the judgment, is it necessary to read the whole judgment, or should you take short notes? Will the short notes work too? I think what you're referring to is the head notes in a judgment. I would certainly not recommend only reading the head notes. The judgment, the head notes may say one thing, but they are ultimately uh, something that is written by the reporter, not by the judge itself. So many times, many important things are missed out. So please read the relevant paragraphs which are referred to in the head notes themselves when analyzing a judgment, because you can't get everything from the head notes. The next question is, can there be personal opinion to get anecdotes to understand case law? You can put it in your own words. You can put it in different ways to analyze case law, but really, ultimately, uh, I would not recommend that you use anecdotes when analyzing a legal problem. Look at it from a objective perspective. Look at the facts of your case and then put them down in the manner that I have suggested. How can students practice IRAC method when they are facing multiple choice question method of exams? So really, multiple choice questions, you can't use the IRAC method. The IRAC method is for subjective answers when you're given a set of facts and you have to apply the facts to a case. For example, a practical question will be useful. You can use the IRAC method for that, but you can't use it for a objective question naturally. For multiple choice, it will be completely useless. But for example, we have in the solicitor's exam, they have they give you a set of facts and they ask you to come up with a solution. So in those kind of problems, you can definitely use the IRAC method. In LLMs, for example, when you are studying either in India or abroad, you can use the IRAC method to answer detailed questions. So it may not be useful for multiple choice questions. How does one navigate through the ambiguities to turn the case in one's favor? So using, what I mentioned about ambiguities was rather that there is no black and white case. Each case has certain gray areas. You have to find out the point in those gray areas which will weigh with the judge in your favor. So there will always be something which is either in your favor or which is against you, which is not apparent from a first reading. You have to dig a bit deeper, find that point which is in your favor, and use it to convince the judge that ultimately you are deserving of the order in your favor, even if there are several points which are against you. Judgments can run into several pages. Do you have any recommendations for reading judgments besides the relevant paragraphs? So judgments can run into several pages, which is true, but it is essential that you read the entire judgment, uh, especially the facts. Sometimes the facts can throw light on the relevant uh, rules of law that they come up with. But many times, what happens is when you're searching for judgments, you're searching on an online resource such as SCC or Manupatra. And when you do that, you put in certain keywords and you get answers to those keywords. So you look at those relevant paragraphs first, but then if you decide to rely on that judgment, then you must read the facts as well, because the facts are important. So yeah, read the facts, read the analysis by the judge, and read the conclusion. Essentially, you're reading the whole IRAC method. The one thing that you need not read in detail are the submissions of the council, because ultimately the judge will be looking at those submissions and analyzing those submissions and coming to a conclusion. Next question is, being a law student whose academic years started recently, reading for case laws are reduced. So, what will be your suggestion for that? Uh, I don't know why reading of case laws has reduced. It's definitely important to read case laws, especially when you are given certain case laws in your textbooks. Of course, they won't extract the entire case law. They may give you certain relevant passages or what the case law actually says. But I would encourage you to look up that judgment online or in any other library or resource and actually read the entire judgment rather than just reading what is given in your book. Or when you are studying for your exams, don't just look at your guide, your law books. Look at also the commentaries on that particular topic, which will increase your knowledge of that particular topic. For example, if you're reading uh, Avtar Singh on company law or on a treatise on transfer of property, do that when you're studying for your exams. It'll increase and broaden the scope of your knowledge, and also refer to some of the important cases in those commentaries when you're answering the questions in your exams. Next question is, dissenting opinions can be helpful and can be quoted. They can be quoted for persuasive value. So what happens is when you're filing an appeal, you will generally be filing an appeal on the reasons which are similar to those which are mentioned in the dissent. So certainly they are important, they're interesting to read, especially if you're in an appellate court, because then generally you'll be using the same points which are in the dissent. But insofar as if you're citing a judgment, then naturally you should cite the majority judgment and not the dissent. But if you are using it for persuasive value, then you can use those points in the dissent in your appeal as well. How do lawyers keep track of different judgments considering there are hundreds of judgments? This is a difficult question because you can't keep track of every single judgment. But I guess what happens is that you will realize what are the important judgments on a particular topic, because they are not that many that come along each year. So, for example, if you're studying, as I mentioned, Section 27 of the Contract Act, then you'll know that Niranjan Shankar Golikari's case, all the way to Percept Demark versus Zahir Khan, all these are important seminal cases. On the other hand, if you're looking at the Arbitration Act, then you'll know that ONGC versus SAW Pipes is a very important judgment. So you'll realize, if you're studying constitutional law, you'll realize that uh, various judgments, the Jabalpur case is an important case. So you don't need to know every single judgment, but you'll realize which are important judgments which deal with the law and either confirm it or change the law to a certain extent. Thank you so much for having me